Justice, we are live when you're ready to get started.
Double safety. Cannabis Compliance Board meeting for March 28, 2023 finally comes to order. I don't know if we have had Member Merritt check in yet. I know she's going to be online. There she is as we speak. We'll go ahead and have the roll call to make sure we have a proper quorum.
Great. Member Merritt,
Present.
Member Durrett,
Here.
Dr. Young.
Here.
Member Guzman Freilich.
Here.
And Chair Douglas.
Here present. First order of business is our public comment this morning. If we have folks in Southern Nevada who wish to make public comment, please come forward. Please state your name for the record.
Good morning, Chairman Douglas. Good morning, distinguished board members, Executive Director Climates. My name is Paul Michael Burgess. For the record, I appear in front of the board to bring insight and some solution to a problem. I have no dog in this fight, as I neither have a license or know anyone that does have a social equity or independent lounge license. I came across this information that the social equity and independent lounges are having a hard time getting funding. The deadline, I believe, is March 31st for these individuals to show the next stages of their movement. The problem is two things. The social equity license has to keep 51% of the company. This stops real investors at the door, as no one is giving over $1 million to a startup with that much control. Jeff Bezos is the second richest person in the world. He only owns less than 12% of Amazon. The other is cannabis is illegally federally. As an investor and an owner, you cannot write off any taxes. You have to eat that cost. The rumor in cannabis is you have to be a billionaire to become a millionaire in cannabis. I brought here today with a solution to this problem. I bring today with me Kurt Walker. Kurt Walker is a VC of 8 years from Silicon Valley and has invested in companies all over the world. I also bring with me Nicole Kyle, who works with DEI nonprofits and also works with DEI businesses to prepare them for being able to pitch and put a business plan pitch together to investors. I also bring with me William Wallace. William Wallace is a businessman who represents other business entities is looking for insight into these licensees. My solution for this problem is that the reason why I'm here is hoping that giving the board justifiable reason to extend the March 31st deadline. I'm going to give all the lounges in here and even, the big time dispensaries $1 million idea. For you social equity lounges and independents, add to your business plan that you are also a tech company that is collecting cannabis data for research. The only law that passed through the federal is a cannabis research bill. This allows for billions of funding of dollars to go out for the research around cannabis. If these lounges were to take that there's a mandatory that a camera must be in these lounges, adding software that tracks the movement of your Patreons can be data points that could be data that collected, given to the state, and then the state can pull down billions of dollars and then have that money split amongst the lounges that are giving that data. This data can also be sold to big pharma. It could also be sold to third parties. This makes you a data collection and research business. If all the lounges in the ecosystem do this at large, that data can be given as I said, for billions of dollars. Lastly and humbly, I request that the board do their due diligence on Kurt Walker for the consideration for the CCB's Pilot Program Commission. He is the gap that the governor's office is looking for with Go Ed and what these small businesses in Las Vegas needs. I ask that he be considered for the Pilot Program Commission. I end with this disclaimer. I do don't believe anything I just said. I do not put myself forward as an educated man. I neither graduated the 8th grade or the high school. I'm not a Dem or a Republican. What I am is a soldier in God's army. I have been given a task, so I'm here to only help. Once again, I have no dog in this fight. I just would like to see these licensees have a chance. Thank you for your time.
Thank you. Additional public comment.
Hello, my name is Kurt Walker. Good morning. I've been in the state for 12 years, and it's been a remarkable experience to see how much people underestimate the city and the state. I've chosen to be here even though I am in other areas and have done investments here in the state and in other states adjacent. Also done quite a bit with building out founder communities. I do believe I have quite a bit of insight and relationships, which we are actively working to bring to court to bring them to Nevada and to have them invest in Nevada startups and Nevada ventures, including those specifically related to cannabis lounges. I'm here to serve and got extensive and you could say substantial experience doing every kind of funding, starting with startup lending, all the way down to being a venture capitalist myself, along with venture debt. And then I have a tremendous amount of experience building out communities where we get business owners together. We're probably several hundred events in at this point. So look forward to seeing how I can be of assistance with those that I do business with and work closely with. Look forward to it.
Thank you. Additional public comment at this time.
Hi, good morning. My name is Nicole Kyle, for the record. What I do, they've already talked about, is helping businesses and nonprofits with their go-to-market strategies and with receiving and getting funding through their pitch decks and connections in the community. Vegas is an incredible place. There's a lot of opportunity here. In the cannabis industry specifically, I see a lot of opportunity, especially if you take it and treat it like a tech. The problem is that businesses in cannabis just want to be treated like any other business owner, and they need to be able to be educated and taught how to pitch and how to do everything just like any other business owner. And so that's my part in this. And I appreciate your guys' time, and I hope you have a wonderful day.
Thank you. Additional public comment.
Good morning, Mr. Commissioner, Commissioners, and Mr. Chairman. My name is William Walls, and I'm here because I want to make it clear that the initiative for social equity is too important to fail. And whatever is necessary needs to be done to make certain that these social equity applicants and licensees have every opportunity to achieve the objective. They set the tone for the future. It's unfortunate that social equity became an issue after Nevada really established its cannabis program. And it's difficult to merge something new into an established program. However, it must be done. It's important that diversity and meaningful interaction and inclusion be evidenced by ownership, leadership, and things like innovative process, as well as the important participation in discussion and participation in employment. That means that we have to go beyond just scholarly discussion. It means we have to meet the problems where they are and solve those problems directly and affirmatively, once and for all. The whole world is watching Nevada to see what Nevada is going to do relative to these few 10 social equity licenses. And if Nevada fails to really meet the moment, it'll send a very bad signal throughout the country. New York is doing an extremely phenomenal job in terms of providing funding. Nevada needs to do more to provide access to capital for these licensees. It also needs to do more in terms of helping to find locations and doing some of the dirty work that they aren't prepared to do and aren't sophisticated enough to do. especially given the short time frame. So at the end of the day, we have to make certain that these licensees have every opportunity to achieve the objectives and goals that were established by the legislation. So we're simply asking that these persons be given an extension. How long, it would be up to you to determine, but an extension that would afford them the opportunity to accomplish the goals and objectives of the social equity program. So thank you very much for your time and attention this morning. Thank you.
Thank you. Additional public comment this morning in Las Vegas. Seeing no others, do we have? Please come forward.
Thank you so much. My name is Catrice Saunders, for the record. I've been a longtime resident of Nevada and a patient advocate. I've been affected by the war on drugs at a state level in Nevada and a federal level in Nevada. I was systematically written out of legislation on multiple occasions. This last round, when they did the lounges, I was 0.5% within the zoning of where I lived. My mother's house was raided by the FBI, the ATF, the DEA when I got set up. She was home alone at the time. I've gone to federal prison protecting patients in the state of Nevada. When I got out of federal prison, I helped open multiple dispensaries and cultivations. Then I was written out after making millions of dollars for the state of Nevada and local business owners. I find myself in this legislative session still fighting for social justice. I still have friends and family members that are affected by the war on drugs. Now I hear that you guys want to put up a new task force to help with the illicit market. Some of those illicit market people are my friends and family members that could not afford to get licenses because you guys have written rules and regulations to write them out. Legal lies are part of the problem in this industry. Social equity was only an afterthought because the local business owners had already put in money for their own lounges. I went to Columbia Business School. It's not a viable option to build generational wealth. The things that need to be put in place for those most harmed by the war on drugs should be open applications to all existing businesses that are open. Labs, cultivations, delivery services, all those things should be able to be afforded to those most affected by the war on drugs. Currently, there is no Black ownership in the state of Nevada for people who have been affected by the war on drugs. I want to know why that I keep on getting systematically written out every time that I try to do things the proper way and be a part of the industry. And here I am 10 years later after my sentencing and being set up after I met President Obama. And I'm fighting for social justice still for myself and others who are left out and don't have a voice and don't feel like they can speak up. And so it's my duty for my children and what I've been through in my experience that I be able to do business in the state of Nevada, considering I've helped make hundreds of millions of dollars for local business owners and the state. I shouldn't have to be fighting for social justice at this late date.
Thank you.
Thank you.
Any other public comment in Las Vegas? Do we have any public comment in Carson City this morning?
No, excuse me, no public comment here, Chair.
Thank you. That would conclude our public comment. Before we get to item number 2, a brief comment that will address one of the concerns that was raised earlier this morning. Mr. Klimas?
Sure, thanks, Justice. Tyler Klimas for the record. And just a quick preview, staff will be detailing a plan to extend by 90 days the date in which those who are selected to move forward in the consumption lounge application process can submit their documents. So just in case individuals leave after public comment, that is coming. It's agenda item number 7, and we can talk more about it, and board members will have a chance to ask questions then.
Okay, having said that, we thought it was an important enough announcement to kick up front after the public comment. We'll move to item number 2, minute meetings. We have for consideration for approval of the February 15th, 2023 Cannabis Compliant Board Special Meeting minutes for possible action. And we have additionally item B, consideration for approval of February 28th, 2023 Cannabis Compliance Board minute meetings for possible action. We can take them individually or we can take them together if there's no additions or comments. It's up to the board members, but I do need a motion.
Member Durrett, I move to approve the meeting minutes listed under agenda item 2A and 2B.
We have a motion to take them in a package A and B. Do we have a second?
Member
This is Member
Merritt.
Young, I'll second that.
We have dueling seconds. Member Merritt, Member Young. Any additional discussion, any corrections for the record? Hearing none. All in favor of the acceptance of minutes A and B, please say aye.
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 Aye. Any abstentions? Any deny? Matter carries unanimously. That moves us to item number 3, consent agenda. First item A, complaints approval to proceed with disciplinary action. Respondent A for possible action.
Tyler Climas for the record. Item 3A on the agenda concerns a single complaint for disciplinary action pursuant to NRS 678A510. The Attorney General has reviewed these violations and has recommended proceeding with disciplinary action. As we've done previously, I'm requesting board approval to proceed with this disciplinary action, and if approved, I will then authorize service of the complaint. Once the board approves proceeding with disciplinary action, service will proceed within a reasonable time, and once the complaint is out for service, we will post it on our website. So as to respondent A, the complaint will allege violations of NRS 678B350, violations of NCCR Regulation 4, Regulation 6, and Regulation 11. With that, I'll turn it back to you, Chair.
We've heard the representation as to the proposed disciplinary action is as respondent A, noting that the board has not seen this document pursuant to the NRS. So we need a motion to go forward with this or not go forward with this.
Chair, I'd like to pull this one for discussion. It would be my preference to not go forward on complaints for a couple of months until the legislature has processed and decided bills that would change our disciplinary process. It looks like those are very likely going to move forward, and I wouldn't want the licensees subject to discipline right now to miss out on the opportunity to have the new process in just a couple of months. So I will proceed however you'd like. If others feel the same, I could do a motion to hold it for a couple of months. I don't think they're extremely time sensitive. We have some cases that have been pending for over a year. Or if that is not others' preference, I could just be a no, whatever works for the board.
If we're going to have the item held, we need a motion or we need to vote it up or down, whichever the pleasure is. The quandary for us is that we don't know the specifics of what is there, and it leaves the parties in limbo. So having said that, whatever the pleasure, if you want to make a motion to hold or whatever, let's see if you have a second and we can move forward.
Okay, I would move to hold this until the July board hearing.
We have a motion to hold item A under 3 until July meeting. Do we have a second at this time? We have no second, so that motion fails. Do we have another motion?
Well, this is Member Young. I'll move that we proceed with agenda item 3A, the approval to proceed with the disciplinary action.
We have a motion for approval to proceed. Do we have a second at this time?
Member Merritt, I will second.
We have a motion, we have a second. Discussion or noting the concerns that were voiced by Member Durrett as to holding this matter at this time. Mr. Durrett, do you wish to make anything else?
No, thank you.
We've had that.
Mr. Chair,
All in
can I
favor?
just,
Yes, please.
if we're still in discussion, I would just wanted to ask, I know we don't have any information on the complaint. but I'm assuming that there's no risk for, there's no safety or health risk involved. Do we
The
even
problem
have
as
that
a board
information?
we have, Member Freilich, the problem we have as a board is pursuant to the legislative dictates as to these complaints. We as a board are not allowed to know what is in those complaints until they're officially passed and served. To be very blunt, I think it's a dumb idea, but I understand we are the ultimate judges, so they don't want us involved until the matter goes out based upon the Attorney General's office, the attorneys involved, thinking there was sufficient grounds at least to go forward. That does not say that they are totally correct in terms of innocence or guilt, but that's the way it works. So we are sitting up here
Okay.
kind of blind. The only thing we can do is to approve the process to allow the complaint to be served.
Okay, thank you. And that would have been my only concern, to hold this out until June or July would be if there was any safety or health issues at stake. Thank you.
Yeah, I think that since we're in discussion, I think that our staff has the ability, depending on some of the things that may be proceeding in Carson City, to hold or slow down the process, even if the complaint gets served. But that's just my thinking, and we can talk about that as a board.
Could I add something? If there was an imminent health hazard, there's separate actions for that, like an emergency suspension. So I think this is necessarily discipline relating to something that is not currently an imminent health hazard.
With that said, all in favor of the motion to allow for service at this time, please say aye.
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 Any nays?
Nay.
Member Durrett is in opposition. It passes with one nay. And I would note, just process-wise and not as a correction, if it's imminent health, we would have already had an emergency suspension as to the matter. They had a right to put forth a plan of correction to get reopened afterwards. So that would have been dealt with. So the imminent would not be no longer before us, but it could have arisen out of that. We just don't know. Moving to item B, consideration for approvals to extend final inspection deadlines. We have a number of TRNVs P098 for different locales. If we have council present on this, if they want to come forward, or if not, we'll start with the possible action on RD 671. That's for White Pine County. Do we have anyone present for that?
Morning.
Good morning.
Shane Terry and representing TRNV P098.
Chair, this is Steve Gilbert. Would you like me to summarize each one for the board?
Briefly for the record, yes.
All right. TRNV was issued conditional retail store licenses in Lander, Pershing, Mineral, Story, and White Pine counties in 2018. Currently, TRNV has not been able to perfect Lander and Pershing because of moratoriums on cannabis establishments in those counties. TRNV 671 in White Pine County was dealing with a moratorium recently. However, that moratorium has been lifted, and it's our understanding that they are moving forward on trying to find a location. TRNV RD 673 in Mineral County, licensee reports that they have found a location, have received approval from the county planning office, and are moving forward in Mineral County. And TRNV RD 675 in Story County are working with the county currently on the Tahoe Reno Industrial Center to get approval for a location. I'm available for any questions if you have them.
Thank you. Board members have any questions as to any of those locations? And we note we run the gamut from moratoriums to types of use, to just change in circumstances. Now where that local county has changed to some of the regulations. So board members, questions as to any specific one?
I have a question, probably best for the director. What is the status on the extenuating circumstances language? Because I think I hate to keep going forward on these without that language in place. I think that, we got to be consistent, and I don't see a reason to deny these in particular, but we really need to put a policy in place about not having forever extensions. And I think the extenuating circumstances language that I requested will help with that. So what's the status of that language?
Just to be frank, I'll speak for the director at this point. He and I have had a discussion about, based upon the concerns you've raised previously as of this issue, that before the next round, which would be November, the board have a discussion. Also allows us to send that notice out to those folks who are situated in this black hole, so to speak. And also state policy in terms of making sure that the requests thereafter for the extension are timely. And if they're not timely, possibly saying you just flat denied. But that's going to be a board item to be discussed. So hopefully that speaks to your first concern. Now the issue is getting it on for discussion.
Okay, so when is the language going to be?
We have not, right now with the bill drop of the hundreds last night, which we were concerned with, I think it took a backseat.
I've been requesting it for a year.
I understand. And we've had other things. And I don't.
Chair Member Direct, Tyler Climbs for the record.
I'm sorry?
This is Tyler Climbs for the record. So the goal here is to have that definition done and in place after board discussion. If it's a regulation, then have it adopted by the time of the expiration of this latest round of extensions, which is November 5th of this year. I think it has to be in place before then, and then we can use that for any future extension requests as we approach the latest deadline.
Great, thank you.
Going back to the agenda specifically, as to TRNV and the 5 properties situated, additional questions or specific questions to any property? We seem to have no additional questions. If we can have a motion to extend, then extend the final inspection deadline to November of this year. If we can have a motion, please.
Member Dret, thank you for putting these on the consent agenda, by the way. I move to approve agenda item 3B, items 1 through 5. Just all of them,
1
right?
through 5, yes.
Okay, just 1 through 5.
Thank you. And with the normal verbiage till the next round, which is November of the year.
I'm sorry, so the deadline will be November.
It's 5th.
November 5th, 2023.
Do we have a second?
This is Member Young, I'll second that.
It's been moved and seconded for approval to the date to keep everything in order with the other extensions to the 5th of November of 2023. All in favor, please say aye.
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 Any nays? Any abstentions? Motion carries. Thank you.
Thank you.
That moves to Green Therapeutics, item number 6 under that. Good morning.
Good morning. This is Duke Fu, representing Green Therapeutics.
Understanding that there's still a moratorium in that locale, is that correct?
Correct.
Is there any movement afoot with any of the county commissioners to change that, or they still?
We've been in contact with a number of different county commissioners there. There has been some movement as far as members on that commission. So, we've been making attempts to reach out to them, and we're kind of waiting to see what happens in the legislature this session, and then afterwards, we're gonna move forward with trying to do some kind of voter initiative there, take it to a vote at some point in time. Thank you.
Thank you. Questions by other members of the board? If there's no questions, do we have a motion?
Member Durrett, I move to approve agenda item 3.6, the extension for Green Therapeutics. The new deadline will be November 5th, 2023.
We have a motion for approval of the extension. Do we have a second?
Second.
Moved and seconded. Any additional discussion? Hearing none. All in favor, please say aye.
Aye.
Aye. Any nays? Any abstentions? Hearing none. Motion carries.
Thank you.
We have item number 4, consideration of the proposed settlement agreement to resolve disciplinary action, Cannabis Compliance Board versus Green Cross Nevada LLC, case number 2022-119.
Good morning, Chair, members of the board. Christopher Rath, Senior Deputy Attorney General. I will be presenting today the only settlement agreement we have under agenda item 4A, CCB versus Green Cross Nevada LLC, CCB case number 2022-19. This licensee, Green Cross Nevada, is a medical and adult use cannabis production facility. The complaint in this case was filed on December 29, 2022. Respondent requested an extension to file an answer in order to engage in settlement negotiations. The extension was granted, along with a second extension to allow us to complete settlement negotiations and draft and finalize the settlement agreement before. The allegations in the complaint arise from a routine audit conducted in September 2021. The complaint alleges seed to sale tracking issues with metric data that did not match physical inventory counts, destruction log issues, and failing to properly file several required reports with the board. More specifically, the monthly activity reports and tax returns did not match the amounts reported in metric. All those issues were covered in the disciplinary complaint at issue in this case. The parties did engage in good faith negotiations prior to an answer being due. As set forth in the proposed settlement agreement to resolve these matters, respondent admitted to one Category 3 violation for failing to follow seed to sale tracking requirements and 2 Category 5 violations for failing to properly submit required reports to the board. Respondent also agreed to pay civil penalties in the total amount of $15,000 within 30 days of approval of the settlement agreement. Respondent also provided a plan of correction, which is detailed in paragraph 18 of the settlement agreement, and the CCB staff has approved this plan. In summary, respondent updated its standard operating procedures, or SOPs, for inventory control and waste management, provided staff training on the new SOPs, and updated its packaging and waste logs. Respondent also hired a CPA to audit tax filings and make sure they match with reports to the board. Based on the foregoing, the Attorney General recommends in the request the CCB approve the settlement agreement. I'm available for questions on this matter. This is counsel for the respondent, Mr. Adam Fulton.
Before we take any questions, counsel on behalf of the licensee, any representations?
Adam Fulton, law firm Jennings and Fulton, bar number 11572, here appearing on behalf of Green Cross Nevada LLC. Would like to thank staff again for working with us through the settlement agreement. I'd also like to note that I know there's been comments made by this board about the amount of the fines, and this one was very appropriate, I think, for the the things that happened here. And I think that it was, I appreciate council and staff taking that into account and giving what I view as a very fair fine in this instance. I'd like to comment. Thank you.
Thank you. Questions by any of the other board members?
Member Drat, I have questions. I agree. The fine amount, even under legislation that's being proposed passes, this would probably be the same fine amount. So I had a question though about the formal warning language. I'm just curious. That's new, right?
No, whenever there's a first category 5 violation, we always put that in the settlement agreement because the first penalty for a first category 5 violation is a formal warning. So we've just been putting it in the settlement agreements.
Okay.
Instead of doing it separately, which has worked.
Does that mean it wouldn't be, this is the criminal law term, but like it wouldn't be enhanceable, or it's not there so that future charges would be an enhancement on that? So, okay, so it wouldn't, this one category 5 violation won't count against them in the future.
Well,
or it's not related to that.
They had 2 category 5 violations. The first one was a warning. The second one was a fine. If there's more within 3 years, then it would rise to the third level of category 5s. If there's not in 3 years, then no more progression.
Got it. Okay. I have a question. So the discrepancies in the amounts, and I wouldn't go into this if it's public record. So the discrepancy in the amounts that were reported, how do you get that far off? I just want to know for future reference. So like the tax reports were so different than what was in metric, but I'm thinking that might not be that uncommon.
So
I'm just wondering how you get that far off.
I apologize. I'm not understanding exactly the question you're asking me.
So this was part of the complaint, is that the sales reflected in metric were different than the quarterly sales reports. They were pretty far off. So how does that happen?
So in
Bad accounting or?
Yeah, so in working it through with my client, one of the issues they had was with the prior staff and the accountant and things of that nature. It was just a recording error. And so we did updated, SOPs. We fired those people. We brought on new accountants. We've got new people in place to make sure that proper reporting is done forward. All that was done in conjunction with staff and council.
Thanks. That's it.
Any other questions by board members? Hearing no other questions, do we have a motion for the acceptance?
This is Member Young. I'll move that we approve agenda item 4A, the proposed settlement agreement between the CCB and Green Cross of Nevada.
We have a motion for acceptance settlement agreement. Do we have a second?
Member Merritt, I will second.
We have a motion, we have a second. Any further discussion? Hearing none, all in favor, please say aye.
Aye.
Aye. Any nays? Any abstentions? Motion carries. Thank you very much, and good luck to your client. And based on the plan of correction, hopefully we won't see them again.
Definitely. Thank you.
That moves us to item number 5, request for transfers of interest, Wellness and Caregiver of Nevada, NLV, LLC, TOI, number 22-00028 through 22-00030, as to C102, RC102, P049, and RP049, and Wellness and Caregivers of Nevada, 2 LLC, C118, RC118, T089 for possible action. If we can have a licensees and our report.
Chair Douglas, members of the board, for the record, I'm David Staley, Chief of Investigations for the CCB. Before I proceed with item A for agenda item number 5, I wanted to provide the board with a brief update of an application that was last seen July of 2022 board meeting. BBMC LLC was a Nevada licensed cannabis company that held cultivation, production, and distribution licenses In 2018 and 2019, BBMC filed various transfer of interest applications for approval of various internal ownership structures, transfers, and for the sale of 70% of its membership to Andrei Muriev through his company, Interreserve Enterprises LLC, which would result in Muriev controlling BBMC. However, on October 10th of 2019, an indictment from the United States District Court, Southern District of New York, alleged a failed attempt by foreign nationals to acquire a Nevada retail cannabis license by donating money to Nevada political campaigns. Governor Steve Sisolak established a multi-agency task force to investigate various ongoing issues involving the Department of Taxation, Marijuana Enforcement Division, and on October 17th of 2019, the Department of Taxation accepted a recommendation from the task force and extended the review period for transfers of interest by announcing the division would not process any new or existing TOI applications until it could complete a more thorough and appropriate vetting process. As a result, BBMC's TOI applications were placed on hold and the proposed transactions have not been approved. The indictment charged 4 individuals with conspiracy to violate the ban on foreign donations and contributions in connection with federal and state elections, conspiring to make contributions in connection with federal elections in the name of others, and with making false statements to and falsifying records to obstruct the administration of the matter within the jurisdiction of the Federal Election Commission. These activities were funded through money provided by a foreign national number 1. On September 21st, 2021, the United States Attorney for the Southern District of New York publicly disclosed that Andrei Muriev was foreign national number 1. On November 29th and 30th of 2021, Interreserve and BBMC respectively requested a withdrawal of TOI 19076. During the TOI investigation, CCB staff identified numerous areas of concern regarding Muriev, including his involvement in campaign finance violations as foreign national number 1, the existence of over $13 million in loans made to BBMC and affiliates by Muriev and his wholly owned companies, and several other issues. On December 14th of 2021, the board considered TOIs number 19037, 19037A, and 19076, and referred the applications back to staff for further discussion, review of the request to withdraw, and review of BBMC and Interreserve's plans to unwind the proposed transaction, including the outstanding debt owed to Interreserve by BBMC. On March 14th of 2022, the United States Attorney for the Southern District of New York unsealed an indictment against Muriev, charging him with making illegal political contributions as a foreign national and conspiring to make illegal political contributions as a foreign national in the name of straw donors. On July 26, 2022, the board again considered TOIs 19037, 19037A, and 19076. At its July 2022 board meeting, the board approved TOIs 19037 and 19037A regarding the internal restructuring and referred TOI number 19076 back to staff for further consideration. On June 29, 2022, BBMC surrendered its medical cultivation licenses, and on December 20th of 2022, surrendered its adult use cultivation, production, and distribution licenses. On March 23rd of 2023, Chair Douglas signed orders of voluntary surrender for all of the surrendered licenses. As a result, BBMC no longer holds any cannabis licenses in the state of Nevada, and staff have determined TOI 19076 should be declared moot and removed from the list of active TOI applications with no further action. I'm available for any questions the board may have on this informational item.
Before the board considers that report, Ms. Ashcraft, as the attorney for the licensees, do you wish to make any statement?
Chair Douglas, this that was
the history.
Okay, so now we're moving on to agenda item number A.
Yes.
Okay, I apologize. Item A are TOI applications by Wellness and Caregivers of Nevada NLB LLC and Wellness and Caregivers of Nevada 2 LLC. Related cultivation, production, distribution companies located in Las Vegas and Las Vegas, Nevada. TOIs number 220028, 29, and 30 request approvals for various internal restructuring among individual ownership for estate planning purposes, addition of 2 passive investors subsequent to the conversion of convertible notes, and among the wellness and caregivers entities to create a more appropriate administrative structure. Wellness and caregivers have also requested waivers of NCCR 5.10 pursuant to NCCR 5.112 and 5.25. If approved, the requirements for prior board approval transfers of less than 5% of wellness and caregivers ownership and agent card requirements for owners of less than 5% will be waived. Wellness and caregivers have adequately addressed the items required in NCCR 5.112 and 5.125 to allow the board to approve such waivers. Staff suggests that if approved, the board limit wellness and caregivers 5.112 and 5.125 waivers to expire on wellness and caregivers' next TOI agenda date. No areas of concern were identified during the investigation of this TOI application. I am available for any questions, and my understanding is that Alicia Ashcraft, Brad Saunders, and Jason Lieberman are available to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Representations for the record.
Good morning, Chair Douglas, members of the board, Director Clymus, Alicia Ashcraft of the law firm of Armstrong Teasdale on behalf of the licensee applicant. With me today are Jason Lieberman and Brad Saunders. By way of background, just a brief affirmative presentation. These licensees are original licensees from the 2014 application round. They've been operational consistently since they first opened. Mr. Lieberman and Mr. Saunders are 2 of the original 4 founders of these companies. So they've been in it for a minute. Before you, this item is in comparison to the informational item presented by Chief Staley, quite boring. This is really a company reorganization. Prior to this, the individuals owned the companies directly. They have 2 different companies, one with cultivation and distribution in unincorporated Clark County, another with cultivation and production in North Las Vegas. What we're looking to do here is insert a holding company so that the individuals would own the holding company, and then the holding company would be the sole owner of the individual operating entities. And then we're moving also the distribution license to a separate entity in and of itself. So it's really just a corporate restructuring for tax and, as Chief Staley mentioned, administrative purposes. No new owners other than those that were added under the previously approved waivers. And then we again ask for a reinstatement of those waivers since the prior granted waivers would expire now that we have a transfer of interest before you. So we do request that the 5112 and the 5125 waivers be granted in addition to approval for this insertion of the holding company. Again, I'm happy to answer any questions that board members have, as do Mr. Lieberman and Mr. Saunders. Thank you.
There was an original kind of flag on this in terms of a tax payment. The representation was that had been paid. Was a correction ever clarified with the tax folks?
It's been a while. Wellness and Caregivers has a wonderful and very competent controller, Leslie Doss. I think that was early on a few months ago an issue. I think she reached out and addressed it. And I'm sorry, it was not a big deal. So I don't remember the specifics of it, but I think it was addressed and clarified. So apologies, I don't have more details on that.
Yeah, it was just noted that as of January 31st, the representations from your folks was taken care of, and for some reason tax hadn't properly documented. That's
yeah. I think it was again. I apologize, Chair Douglas. As I recall, it was a mailing issue. It had been timely mailed. It was kicked back for some reason, and we worked it out with Department of Tax. But that's my
yeah. There were no other flags or concerns, and this seems to be satisfied. So
appreciate it.
With that, questions by other members of the board.
Mr. Chair, I have a question. We do have the financials for 20 and 21. I'm just wondering, how was 2022 as far as business goes?
2022 was excellent. We experienced slight dip towards the last quarter due to some internal issues, but sales have been steady for the majority of the year.
Would you identify yourself for the record so that our person?
Excuse me, I'm
That's it.
Jason Lieberman. I'm a manager and founding member
Thank you.
of all of these entities.
Good to hear. Thank you.
Any other questions? With that, do we have a motion for approval of the TOI request with the appropriate conditions?
Member Durrett, I move to approve the request for transfer of interest under agenda item 5A related to wellness and caregivers of Nevada with the conditions that the waivers of NCCR 5.110 pursuant to NCCR 5.112 will expire on the next agenda item.
And if
Did
we
I,
could
did I
also
miss one?
add NCCR 5.125.
Yes, as well as NCCR 5.125.
Chair Douglas, members of the board, David Staley, for the record, can we clarify that they would expire in the next transfer of interest agenda item? What we've experienced in some cases is that we've had licensees come for us with a management services agreement, and prior language has always
okay.
been simply their next board appearance, and we found that that doesn't work really well for them. So we'd like to suggest that you condition that for their next transfer of interest application, please.
That was the basic proposal that was offered to clean up and, as you're stating, making it consistent with the others for the next TOI request.
Okay, just to make it clean, those waivers will expire on the next agenda item related to transfer of interest.
Thank you. Do we
Second,
have a second? Who is our second?
Member Freilich.
Thank you. We have a motion, we have a second. Any additional discussion? Hearing none, all in favor, please say aye.
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 Any nays? Any abstentions? Motion carries. Thank you very much, and
Thank you
for
so much,
having
members
no
of the
concern.
board, Chief Staley, and especially Investigator Angela Dean for all her work on this item. Thanks so much.
Thank you. That takes us to item B under that topic, Silver Stage Wellness LLC TOI 210051 C042 RC 042 D49 RD 049 P022 RP 022 for possible action.
Chair Douglas, members of the board, for the record, I'm David Staley, Chief of the Investigations Division. Item B is a TOI application by Silver Sage Wellness LLC, a vertically integrated cannabis company in Las Vegas, Nevada. TOI number 21000051 was filed in July of 2021 and later amended, requesting the approval for the sale of Nick Heist and Kaven Calipari's combined 10% ownership to the James M. and Pamela A. Blayco Revocable Trust, as well as the subsequent transfer of 10% ownership from the Blasco Trust to the Peter J. Becker and Angela A. Becker Revocable Trust. The investigative report indicates that Silver Sage will purchase Heiss and Calipari's ownership, but the Blayco Trust will be the entity purchasing the ownership before it's transferred into the trust. The transfer of 10% between the Blasco Trust to the Becker Trust will be completed through the forgiveness of a loan between the Beckers and Blascos. Staff have identified an area of concern regarding this TOI because James and Pamela Blasco transferred their combined and individually held 81% ownership of Silver Sage into the Blasco Trust in December of 2018 without prior approval by the Nevada Department of Taxation or the CCB. I'm available for any questions, and my understanding is that Pamela Blasco, Whitney Welch Kerms, Mark Ferrario, Peter Becker, and Angela Becker are available to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Representations for the record, please.
Good morning, Chair Douglas, members of the commission, Director Climus, Chief Staley. Mark Ferrario from Greenberg Traurig, appearing on behalf of Silver Sage, and also Ms. Blasco, who is to my right, and Whitney Welch is to my left. This was accurately described by Chief Staley, and he did identify an area of concern. That was the transfer to a family trust. That was done purely for estate planning purposes. You can see in the submission that we gave to you, unfortunately, Mr. Blasco, who was a founding member of the company, fought a multi-year battle with cancer. That transfer was part of his estate planning in conjunction with, I guess, recognizing that things may not work out well, and they didn't. During the course of doing that, it was an oversight not to notify the Taxation Commission. We understand it was a technical violation, but we're here now to clean all that up and get the ownership where it should be. So with that, we'll answer any questions, but I think it's really a straightforward matter at this point in time. We're taking two minority partners out, they're not partners, but members out, putting two in, and moving forward with the company. Ms. Blasco now owns 81% of the company and will own it in their trust. So we'll answer any questions you.
Questions by board members?
I have a few questions. First, for Chief Staley, I have gone over all of the changes and transfers and interest since 2015 multiple times. I've had to draft them, like a report listing them. Every time we talk about it, I've forgotten. I would need to go back, research, because there were so many changes back and forth. Then you have to look at medical versus adult use. I know this is a lot to ask because these reports are so extensive and well organized. Can we get a reminder when there's an unapproved transfer of what the law was at that time, up until the CCB adopted its language? So, for example, in 2018, there was medical language at that time. There was adult use language. I don't remember what applied at that time. There was also even a little, not just the statutes, the policies were different at one point about you could spin off a license, but you couldn't sell a part of the company, something like that. It might have been vice versa. So I have it somewhere. Maybe I could pull it and send it, but if we could just get a reminder so I don't have to pull it every time of what was the law at that time, because I think in 2018, I doubt anybody who put their assets into revocable trust would have even thought that they needed permission. And the person now who did it has now passed. So I'm not at all concerned with, I'm not concerned with that transfer having happened, although, now now everybody knows better now. I have a question for the licensees. I see a major change in management. I think Silver Sage has been a leader in the area, has been very successful. I'm a little nervous because I don't see that the new management has cannabis experience, or is that maybe just not listed on the, who's going to be in charge with the cannabis experience?
Well, the new management does have cannabis experience and had worked for the company for a couple of years. So was brought in actually during this period of illness to help with some financial oversight. There have been some changes there. Ms. Blasco, has come in and wanted to, in her words, I guess, and I'll let her speak for herself, kind of get back to what their original mission was, and shuffled the deck, if you will. And that was after her extensively examining what was going on and talking to people, and then found somebody she was comfortable with to help her run the company. She can speak to that. Go ahead, ma'am.
Good morning, everyone. Thank you for your time. I really was looking to, because my husband was sick for so long, we had a mission when we began this process. We have two special needs sons. That was our motive and still remains the mission. And I'm looking to get back in as a face and become more part of the community, as we stated in our original application, and move towards more philanthropic endeavors. Is
Thank
that
you.
answering your question?
Well, I've always heard the best about your family. Thank you. Thank you for everything you've done for the community. The one that I had the personal pleasure of witnessing was when you did a lot during COVID, donating a lot of masks and resources. So I've always heard amazing things, and I'm sorry about your husband. And thank you very much.
Thank you.
Any additional questions, comments by board members? From the chair standpoint, the recommendations we've been provided, sub 4, sub 5. One is conditional approval with a fine. The other is to grant the pending request for transfer of interest and refer it back to the Attorney General to take a look to see whether or not it's appropriate for a fine or at what amount. I'm inclined to want to grant the pending request, transferring the interest, referring it to the Attorney General's office, and looking at a fine much less than what was projected under conditional. To channel Ms. Durrett.
Finally.
Having said that, that would be my position, but any other board member wish to make any comment?
Mr. Chairman, I just have a question for the licensees.
Please.
First of all, my condolences on the passing of your husband. And that brings me to my next question on the transfer of interest to the trust. Were there any beneficiaries that benefited from that transfer, or have all of the profits just been held in trust?
This was purely, this was the most basic kind of estate planning transfer. Mr. and Mrs. Blasco owned the interest in Silver Sage before the transfer. They controlled it after the transfer. So there was really, from an operational perspective, absolutely no difference from my perspective, other than it did go into the trust, but no one had control of that trust other than Mr. and Mrs. Blasco. Are there beneficiaries? Ultimately, if they both pass, yes, there will be beneficiaries. It'll be I can't think of them off the top of my head, but children. But no, I don't know if you broke it up into two or whatever. But the control remained the same. So from an operational standpoint, from a licensing standpoint, for what I think you all need to be concerned about, I don't think there was really any difference. So they ran it before, they ran it after. It was just held in the name of the trust.
Thank you. Member Dredd, it's kind of a follow-up. I think that's a really good question, because the concern would be about those beneficiaries' role and if they have like a controlling interest, basically. But potentially that wouldn't be any different than if you didn't have the trust in place. It would just go to them through intestate succession and then be the same thing.
You're exactly right.
But I think it's a really good question, because we need to maybe have a vetting of that. Okay, I'm just gonna leave it at that.
If we have no other discussion or questions, can we have a motion?
Well, I have one more discussion point. I don't want to see it referred to the AG, so I think but I do approve. I agree with the condition. Could those be two separate votes?
We have no motion on the floor. You can make whatever motion you wish.
Okay, thank you. I would move to approve the requested transfer of interest number 2100051. My motion would not include transferring it to the AG, but subject to the chair's approval, maybe that could be a separate motion.
We have a motion for just a approval, indicating no violations at this time. Do we have a second?
Second.
The motion, we have a second. All in favor, please say aye.
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 And the chair says nay. Matter carries. Thank you.
Thank you very much. I want to in particular thank Chief Staley and most particularly Maggie Adams for her professionalism and courtesy. It's a pleasure to work with. Thank you.
That takes us to item number C, MA and Associates LLC.
Chair Douglas, members of the board, for the record, I am David Staley, Chief of Investigations Division. Item C are TOI applications by MA and Associates LLC, which holds a laboratory license in Las Vegas, Nevada. TOI number 21022 was filed in July of 2020, and 220041 was filed in November of 2022, requesting approval from Mark Sarna through MA Analytics LLC to purchase 95% ownership in MA and Associates from Pazoo Inc., a publicly traded company or PTC, with Ben Bingham retaining a 5% ownership as an equity grant. Sarna's purchase of MA and Associates ownership will be effectuated with some cash, but the bulk of the purchase will be through the retirement of over $2 million in loans made by Pazoo to Sarna. There are areas of concern in this TOI report regarding the unapproved transfers of interest and reporting of false information to taxation in the CCB. During June of 2014, the Nevada Department of Taxation regarded the ownership of MA and Associates as 40% held by Pazoo and the remaining 60% held individually between Antonio Del Hierro, Bingham, and David Lieberthal. During August of 2015, in the United States Security and Exchange Commission, or SEC Form 10Q filing, Pazoo disclosed that it had purchased the 60% of MA and Associates that it did not already own for approximately $1.7 million. Thereafter, Pazoo's SEC filings recognized MA and Associates as a wholly owned subsidiary. SEC reporting requirements are stringent as the investing public relies on a company's disclosure to determine investing strategy. By reporting in its SEC forms that it had acquired MA and Associates in June of 2015 and as a wholly owned subsidiary thereafter, Pazoo, its executives, and its independent public accounting firm certified that the filings meet the requirements of generally accepted accounting standards, public company accounting oversight board requirements, and in accordance with federal securities laws and applicable rules and regulations of the SEC. These standards include rigorous tests to verify that a company can recognize other entities as related parties, entities where the company has significant control, and entities that can be recognized as under complete control and wholly owned. In response to board agents' request for explanation, Pazoo explained that it had not completed an unapproved transfer of M&A associated ownership through its reported acquisition in June of 2015 because the purchase agreement required approval by appropriate regulatory authorities before it could be completed, even though the companies never filed a request for approval of the transfer of interest and continued to report MA and Associates ownership as that recorded by taxation in 2014. As a result, since they had not received taxation approval of the transfer, it could not have happened. As a result, it appears that Pazoo's SEC filings contradict its assertion that it never completed the acquisition of MA and Associates. None of these transactions received taxation or board approval and are unapproved transfers of interest. The unapproved TOI issues are further confused because MA and Associates submitted purchase agreements from 2017 for Sarna to purchase the amounts previously owned by Del Hierro, Bingham, and Lieberthal from them individually, while Pazoo was reporting 100% ownership of MA and Associates as its wholly owned subsidiary. In addition, all renewal documents submitted to taxation between 2017 and 2020 falsely reflect the June 2014 ownership structure. Then in December 2017, Sarna entered into a membership interest purchase agreement with Pazoo for a partial purchase of MA and Associates, followed by a second purchase agreement on November 2022, which will result in Sarna owning 95% of MA and Associates. Sarna did not elect to exercise the first purchase agreement until July 9th of 2020, and filed TOI 21022 shortly afterwards. I'm available for any questions, and my understanding is that Mark Sarna, Steve Laszlo, Benjamin Bingham, and Amanda Connor are available to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Representations for the record, please.
Good morning, Chairman, members of the board. Amanda Connor with the law firm of Connor and Connor. I also have my partner Derek Connor here with me, and in attendance in person today is Mr. Mark Sarna of MA Analytics, the proposed buyer, and Mr. Steve Baslow as well. I did want to clarify a few things. I think Mr. Staley, in giving his report, misstated that the loans were to Mr. Sarna from Pazoo, and it's actually the opposite. It was from Mr. Sarna to Pazoo. I believe the board does have MA and Associates written response in front of them. And has been provided copies to review it. I know it's quite large, so I appreciate and thank the board for taking the time to review it. But to clarify, it is MA's position that there were no false statements made to Department of Tax or prior regulating agencies, that the ownership in 2015 did not change because of the conditions precedents that did not occur in the purchase agreement, and therefore the reported ownership, which was as reported and approved by Department of Public and Behavioral Health, was reflected in their records, was what the company had, was what they put on their renewal forms. All of it matched up because that is what happened. The condition precedents hadn't occurred. And then separately, given that that hadn't occurred, the individuals had transfers to Mr. Sarna's company, MA Analytics, and as Mr. Staley indicated, he elected to pursue that purchase option in consideration for forgiveness of debt, originally filed in 2020, and they reached agreement to acquire the remaining interest except for 5%, which will remain held by Mr. Ben Bingham, and that was submitted in November of 2022, if I believe. So those are the transfers before you. Is for Mr. Sarna through his company to acquire 95%. I will be happy to answer any questions about any of the areas of concern. Again, I know a quite lengthy memo was given to you regarding those. Mr. Sarna has traveled from New Jersey. He is very excited to get involved in the cannabis industry here in Nevada. He is committed to running a compliant, excellent lab, and we hope that this sets the company on the right path and trajectory forward. Thank you.
Questions by board members?
I have a couple questions. Member Drett, again, in 2015, the rules, before 2015, you couldn't transfer a registration certificate. 2015, that was changed. So even if transfers occurred in 2015, I don't think there were any rules about what, I don't know if there was a specific prohibition on doing these transfers. And it would have been back at DPPH at that time, especially because, usually statutory language says something like the regulator will adopt regulations on this. I can picture the NRS back in 2015, and once it was changed in 2015, it didn't say that. So there is probably a regulation related to it, but I think the statute just said, okay, you can't transfer registration certificates, just basically cross out cannot. And so then you could transfer regulation or registration certificates. So even if it happened in 2015, I don't know that violated a statute. Does that sound right?
Member Durrett, thank you for that question. Yes, if my recollection serves me correctly, when it was originally adopted regarding medical marijuana establishments in 2013, there was a prohibition completely on transfers. In the legislative session on 2015, that was changed. However, as we all know, when statutes or the legislature adopts changes in law, then there is a period of time until regulations are adopted regarding that. So that is my recollection as well.
Is that also applicable to adult use cannabis products?
Adult use was not was not legal in 2015.
I understand that, but my general question referring to transfer, since you're merging the two together, clarification, if any.
So with regards to adult use, it was adopted or legalized by the voters in 2016, went into effect in 2017, and there were regulations in effect at that time regarding transfers. But again, the company's position is that, as stated in the memorandum provided to you, that there were conditions precedent to occur, and that did not happen. And then separately, throughout this process, there was agreements reached with Mr. Sarna to begin transferring interest to him once certain conditions were met.
Mr. Staley, do you have something?
Chair Douglas, members of the board, David Staley for the record. My understanding of both the NAC and the I don't think we cited the NAC in the report, but both the NAC and the NRS required prior approval of transfers of interest. The issue at hand is that the licensee's argument that the transfer did not occur because it needs to be the language in the agreement requires board approval or prior approval by taxation or so let's see, the language in the agreement required approval by the board or the Department of Taxation. The company's argument is that since they have not received that approval, that transaction has not occurred. We place a great reliance on the requirements for SEC filings, and all the indications are that the transaction did occur, that this company has been a subsidiary since 2015, and they've been recognizing revenue from that transaction. The second issue is that they have been reporting to both the Department of Taxation and the Cannabis Compliance Board the old ownership, despite all the meeting all the requirements of the SEC, GAAP, etc., and recognizing the transactions as it had occurred.
Understand. Additional questions by board members at this time?
Member Drutt, the money did get transferred, right? Or it was a cancellation of debt?
So Mr. Sarna had been loaning money for operations and through various loan documents. And the agreement is that if that there is a cancellation of debt, there is also some cash purchase price, but yes, the majority of it is through cancellation of debt.
Members of the board, for the record, David Staley, the original transaction was that Pazoo Inc. paid the individual shareholders in 2015 and acquired their cannabis license from them at that time. The second part of the TOIs that are before you is the ability for Mr. Sarna to come in and purchase it from Pazoo.
Got it. Okay, thanks.
Ms. Merritt, board member Merritt, you had your light on. Were you going to make a comment or? Okay. For the record, from the chair, it's been noted that the company's in pretty good shape. All the parties have been moving to bring it forward and put it in a good position at this time. There seems to still be a disagreement about whether or not we have a violation. I would make a motion to approve the TOI, but I'd also refer it back to the staff for the parties to sit down, sharpen their pencils and see if they can iron out their differences or whether or not either a settlement agreement or a complaint should be issued. but allow the parties to clarify their positions if they're appropriate, not have to go forward. So that would be my motion. Okay. Approval, referred back to staff to sit down with the licensee to make a determination on the finer points. And thank council and staff for the representations this day. We have a second to that motion.
This member Young, I'll second that.
Been moved and seconded. Any other discussion as to that proposed motion? Hearing none, all in favor, please say aye.
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 Aye. Any nays? Any abstention? Motion carries. Thank you.
Thank you, members of the board, Mr. Staley, and especially thank you to Maggie Adams and Rachel Brenner, who worked very hard and tirelessly on this transfer. And just one thing, Mr. Sarna is very excited to be part of Nevada's cannabis industry. Thank you.
Thank you both, and thank council for the arguments. We move to item D, GPRP Distributors LLC, TOIs 20039 T095, and Deep Roots Harvest Inc., C070, RC070, C185, D165, RD165, D200, RD397, RD398, RD399, RD400, RD401, P088, RP088, P121, T024 for possible action.
Chair Douglas, members of the board, for the record, I'm David Staley, Chief of the Investigations Division. Item D is a TOI application by Deep Roots Harvest, Inc., a vertically integrated cannabis company. TOI number 2200039 request approvals for 2 internal restructuring transfers that were result in Deep Roots distribution license T095, transferring from subsidiary GPRP Distributors LLC to Deep Roots itself, as well as the insertion of a holding company, Deep Roots Holding Inc., between the company's individual shareholders and Deep Roots and its licenses. Deep Roots has also requested waivers of NCCR 5.110 pursuant to NCCR 5.112 and 5.125. If approved, the requirements for prior board approval of transfers of less than 5% of Deep Roots ownership and agent card requirements for owners of less than 5% will be waived. Deep Roots has adequately addressed the items required in NCCR 5.112 and 5.125 to allow the board to approve such waivers. Staff suggests that if approved, the board limit Deep Roots 5.112 and 5.125 waivers to expire on its next agenda date. No areas of concern were identified during the investigation in this TOI application. I'm available for any questions, and my understanding is that Lori Rogich and Keith Capurro are available to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Representation for the record, council, and any statements you wish to make.
Good morning, Chairman Douglas, members of the board, Director Climas, Chief Staley, and Agent Covington. My name is Lori Rogish, and I am here on behalf of Deep Roots Harvest Inc. and GPRP Distributors LLC. With me today is Keith Capurro. Mr. Capurro is the President, Chief Executive Officer, and owner and board member of Deep Roots Harvest. He is also a manager of GPRP Distributors. In August 2022, we purchased GPRP Distributors, and it became a wholly owned subsidiary of Deep Roots Harvest. We respectfully request your approval to dissolve GPRP and to transfer its license to Deep Roots Harvest. We also request your approval to restructure Deep Roots Harvest and to form a holding company. The owner's interest in Deep Roots will be transferred and contributed to Deep Roots Holdings, Inc. in exchange for capital stock in the holding company. Through this transaction, Deep Roots Harvest will become a wholly owned subsidiary of Deep Roots Holdings, Inc. Thank you, and we are here today to answer questions you may have.
Members of the board, questions? It's nice to have an easy one. If we have no questions, if we can have an approval, and do we need the waiver also pursuant to NCCR 5110. Staley. Okay. If we're going to have a motion for approval with the waivers.
Member Dret, I move to approve the request for a transfer of interest under agenda item 5D. These would also include granting the request for waivers of NCCR 5.110 pursuant to NCCR 5.112 and pursuant to NCCR 5.125. Those would be set to expire on the next agenda item relating to transfer of interest.
With that having been said, that mouthful, do we have a second?
Second.
We have a second.
Member
Ms.
Freilich.
Thank you. Any other questions or statements? Hearing none, all in favor, please say aye.
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 Any nays? Any abstentions? Hearing none, matter carries. Thank you very much.
Thank you. And we appreciate Agent Covington's professionalism and his guidance through this process. We would also like to use this opportunity to say hello to the newest member of the board, Member Freilich. We look forward to working with you.
Thank you.
That takes us to item number E, Green Mining Concepts. TOI 19072, 19072A, and 220031, C093, RC093, P048, RP048, D105, RD105, D145, RD145, and Natural Medicine LLC, CT, I guess it's 01, OI, number CT C210022, C210023, C22019, C052, RC052, P039, RP039, D089, RD089, T077 for possible action. Mr. Staley.
Chair Douglas, members of the board, David Staley, Chief of Investigations for the record. Item E are TOI applications by Green Mining Concepts, Inc., a vertically integrated cannabis company in Las Vegas, Nevada. TOIs number 19072, 19072A, and 2200031 request approvals for some internal restructuring and addition of some new investors, as well as the proposed sale of a conditional dispensary license held by subsidiary Exhale Brands Nevada 3 LLC to Natural Medicine LLC. Natural Medicine received conditional approvals during the board's July 2022 meeting for internal restructuring needed for capital infusion and the proposed purchase by Natural Medicine of distribution license T077. This TOI investigative report includes a full updated review of Natural Medicine and found that it has complied with all conditions associated with the conditional approvals. As a result, if the board approves the results of this investigative report, CTOIs C210022, 00023, and 00019 will convert to full non-conditional approvals. This is the first time that one of your conditional approvals has come back to you for full approval. Natural Medicine has also requested waivers of NCCR 5.10 pursuant to NCCR 5.112 and 5.125. If approved, the requirements for prior board approval of transfers of less than 5% of Natural Medicine's ownership and agent card requirements for owners of less than 5% will be waived. Natural Medicine has adequately addressed the items required in NCCR 5.112, 5.125 to allow the board to approve such waivers. Staff suggests that if approved, the board limit Natural Medicine's 5112 and 5125 waivers to expire at its next agenda date. There are areas of concern in this TOI report regarding lack of requested documentation, unapproved transfers of interest, and a balance due owed to the Nevada Department of Taxation of approximately $940,000. It appears that the transfer of interest requested pursuant to TOI number 19072 have already occurred because Green Mining financial statements reflect the infusion of additional capital and license renewal applications for years 2019, 2020, and 2021 include the ownership structure requested in the TOI. I am available for any questions, and my understanding is that Adam Fulton, Brian Hardy, Peter Findley, Lindsay Clements, and L. Naito are available to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
One lead question before I ask the licensees to respond. You indicated they did not respond to certain things. If you could identify that for the board so that we would understand and council and the applicants would have an opportunity to respond to clarify.
David Staley for the record. The agent indicated that amounts of information regarding financial hold on, let me make sure I'm doing this correct. There were various sets of information that would help the investigative agent prepare the report for you that were not provided.
How germane are they to this issue today?
David Staley for the record, Chair Douglas. The information requested included documentation regarding the transfer of interest, including purchase agreements and company financial statements. That was in April of 2021. We internally decided to, one moment, please. Chair Douglas, members of the board, for the record, David Staley. The investigative agent indicated that we did receive the financial statements, and those are included in the investigative report, but the original purchase agreements were not submitted. So they are somewhat relative to important in this case.
Now, if we can have representation from council and licensees, I wanted to make sure we were on the same footing with what the issues were.
Chair, members of the board, Executive Director Brian Hardy with the law firm of Marquis Arbach. I have with me also, I represent Green Mining Concepts, which is the entity. I have with me also Adam Fulton, who represents the proposed ownership, the new owners that would be coming into the entity, along with Pete Findley, who is one of the original founding owners and members of the entity. We also have with us over here.
Good morning, Chair Douglas, Board, Executive Director Klimas, and Chief Staley. Stephanie Smith on behalf of Natural Medicine with the firm Ben David Law. I have with me Lindsay Clements, who is the Director of Operations for Natural Medicine, and so El Nato, who is the Director of Compliance for Natural Medicine.
Thank you.
Thank you, Chair. So we have gone through, this is a request originally came through in around 2018 was when the original one was provided over to and submitted to the Nevada Cannabis Compliance Board. Its predecessor, the DOT. That's who this originally was submitted through the application. It's been through it's been going through that process, which is why you see a number of iterations. What we're looking at now is a final approved transfer that would allow previous approved ownership of 50-50 being held by Pete Findley and Baxter Baldwin to an approved ownership that would have the percentages that are listed. Originally, there was going to be a listing where Health Dev LLC, which is Brian O'Reilly, was going to have a percentage ownership in this. However, you'll see that there was a proposal and transfer of interest to have him pulled out of that and that transfer assigned over to Bill Barth because Mr. O'Reilly is going to be going for a gaming license and can no longer help. So during the duration of things, since 2018, things have changed. And so he's going to go into the gaming industry. So he needs to go ahead and pull back on that ownership. So that's going to be ownership that's going to be assumed by upon the approval of this board by Mr. Barth. With respect to the questions that arise relative to certain documents being requested, I was brought into this as of recently, and all the requests that have been made by the board, we've made sure and provided. I want to thank Rachel for all of her hard work and that she's been working diligently with us to be able to get those. And if there were additional documents that were necessary, we were unaware of those at that time, but we're happy to go ahead and identify all of the ownership, which was identified in a letter that was sent on March 14th, 2023, listed the ownership and proposed structure, and kind of give a history on exactly what had happened with these licenses, because they are these transfers of interest were aged a bit coming from your predecessor. If you have any questions, I'm happy to answer those.
I have questions, but
Absolutely. Let's see what we can answer.
one question is, how are we to be assured that the amount outstanding to the treasurer, well, tax matter will be taken care of?
So one of the things that you can see from the asset purchase agreement that was provided is there is a sum that was significant above the amount that's going to be coming in from this sale that we utilized to pay that tax amount. And in fact, consistent with the letter that was provided to the board on March 14th, we indicated that the way that the proposed structure is going to be, as you know, we have Green Mining Concepts as a parent company. There are two kind of subsidiary companies, both of which hold different licensing. One of the dispensary licenses, which is going to be sold, will then garner revenue, which will go to the parent company, which will then be reinvested into the other subsidiary to pay off its tax obligation. So as a result of this proposed transfer, all tax obligations will become current, and we've coordinated with the Department of Taxation to ensure that happens.
Yeah, because the concern is having something that guarantees that, so we don't have to put a condition on it that affects the new ownership.
We understand.
The other is going back to the request that was made for the information on the first transfer. That information, Mr. Staley, where are you with that?
Chair Douglas, members of the board, for the record, this is David Staley, Chief of Investigations. At the time the investigative report was completed, I think we were missing purchase agreements or other documentation governing the new owner's acquisition of ownership.
Questions by other members of our board?
Member Dret. So the transfer from, it was 2018, right? TOI number 19072. The concern is that that occurred before it was officially approved. What are your thoughts around that? Did that not officially occur because the funds were transferred?
So as you know, one of the things that Mr. Barth, who is one of the principal owners of this, the companies needed certain funds to be able to proceed. So they've got loan agreements back and forth. Those loan agreements will be forgiven upon consummation of the purchase. But that's what they sort of stand as right now, are loan agreements to the company.
Okay, well, yeah, that's different. Because it is a little murky about whether or not a transfer has occurred, and I don't know if that we have a clear definition. I think the one thing we can look at is, what are you saying in your SEC filings, and did you transfer the money? So let me ask Chief Staley, could those just have been loans versus an actual transfer of interest? Again, 19072 stemming back to 2018.
Chair Douglas, members of the board, for the record, this is David Staley. Our records indicate that sometime during the fiscal year 2019, Findlay and Baldwin's ownership was diluted. The ownership of Green Mining changed to include the new investors. So whether or not the compensation of either additional capital or loans was through shares, it really doesn't matter. The ownership structure of the company changed and is covered on page 16 of your investigative report.
How do you determine that it was changed? Yeah. Was it changed?
There's been no share certificates issued or anything of the sort. What we have is we have a proposal, which is in, and if you look at the letter that was sent from my office on March 14th, we identified the notices that were there. We actually copy and paste pictures of that on the proposed ownership, indicating that we were aware these are proposed ownership and that there was going to be proposal or the board, at the time it was Department of Taxation, for these transfer of ownerships to occur, and that they couldn't occur until there was approval. And so there's been no share issuances, there's no anything like that, other than there were loan agreements, and there's been amended loan agreements as additional funds have needed to come in. The companies, they're attempting to operate in a fiscally appropriate manner. It's one of the reasons they're looking at their assets and saying, look, can't get all these out of loans. We're going to sell off one of the assets, which we propose to do today, in order to get those additional funding, in order to be able to structure and ensure things up with that. They can have some forgiveness of those loans by turning some of those into ownership interests.
Thank you for sticking in there, by the way, because this has been, there have been some ups and downs in this industry, and it's been really hard. And I know a lot of people out there missed a lot of their kids' soccer games while they're trying to keep their businesses afloat. So I don't know if, I mean, we can't be finders of facts at this hearing, but I'm trying to figure out if there is a discrepancy. Is there a conflict in the facts that are being presented? Because so you heard there. So how is this a transfer if their structure didn't change and there were loans involved? Disagree.
Chair Douglas, members of the board, for the record, David Staley for Chief of Investigations. I think part of the confusion is that as your report indicates, there were many requests for additional information for the information that could either confirm that the TOIs had not occurred, or confirm that the TOIs had occurred. The agent indicates that contacts were made 6 or 7 times during 2021. I think due to the lack of response, we compiled the information we had available and provided an investigative report for the board. Certainly, if additional information can be provided to clarify the situation, we would welcome it.
Thank you. It's so much more helpful when this stuff is provided and we're not doing this digging at the hearing. But thank you very much for that.
Any other board member wish to weigh in? I think under the
Member Freilich, I
circumstances-
just have a question with regard to licensing. Is there still a $15,000 outstanding fees, renewal fees for 2021 and 22, in addition to the tax, outstanding tax, the 900,000 tax, as well as the 15,000 for CCB renewal fees?
Member Freilich, members of the board, David Staley for the record. Our understanding is that the current, that the balance due to the Department of Taxation is still outstanding. And the company has explained that the funds from the proposed sale of the license will pay those off. As to any renewal fees, those are typically cleared up at the time of renewal when the company renews its licenses. That's the mechanism by which we typically get those fees paid.
The problem is that in your report, it indicated there were a number of years where there were still outstanding balances. So is that just a misstatement in that report?
I apologize. David Staley for the record. Can you please point me to the page that information's on?
It's page 8 in the middle of the page under additional areas of concern.
Thank you. Page 8.
Correct.
Page 8 of the Green Mining Report is background of business. Am I missing?
The renewal fees were for 2020, 21, and 22. Had not been paid. The total amount owed is 15,000, and it's still outstanding.
Member Freilich,
I
could you
apologize.
please-
I apologize. I am looking at a completely different report. So,
Thank God for that. I had no idea what you're talking about. I think
And if
with,
it was
with,
and if it was April 1st, I would say happy April Fool's Day, but sorry about that. Apologize. Thank
Member
you.
Freilich, members of the board, for the record, this is David Staley. We have in this case the outstanding tax amount, and the company has explained how that will be covered. We also have some questions about whether or not transfers of interest occurred, and that's primarily due to the lack of clarifying information from the company this time.
We still seem to have some loose ends in this matter. What I would like to do, at least I would propose, is that we grant this matter conditionally. Take 60 days to provide other documents to get this completed so that we don't have problems, and report back to the board whether or not this needs to go to the Attorney General's office for other things, or whether the concern and questions have now been satisfied, but would grant the conditional approval at this time. A note for the record that Natural Medicines has satisfied all our requirements, so we're just kind of trying to get those loose ends with Green Mining Concepts cleared out. It sounds like we're awful close, and hopefully in 60 days we can get this clarified. Don't want to hold up your transaction. I don't know what that does to it at this point. Mr. Fulton.
Thank you, Chair. Real quick, one of the issues we're dealing with is we want to make sure that we get the dispensary license transferred pursuit. So there's really, I look at this as like two separate transactions, right? One is an internal restructuring, which the board has questions on. I understand that. So my request would be to make that piece of the TOI conditional, but make the actual transfer of the dispensary license actually a final approval. I look at it as kind of two separate transactions. And based on what we're trying to do with issues with the city of Las Vegas, it's very important that the final transfer occur today. So I just want to clarify that and make sure we're clear on the record on those points.
So Staley, I look for your guidance on that. You kind of hinted that way, but can we do that at this time?
Chair Douglas, members of the board, David Staley, Chief Investigations. If I understood your proposed condition, you were going to put a blanket condition of 60 days on the transfers. If you applied that condition only to the internal restructuring of Green Mining, I believe that would work for both staff and for the company. In addition, with the transfer to Natural Medicine, I think, that would give the company the opportunity to clear up any outstanding tax balances. So within 60 days, I think we would be able to present a wrapped up product for your consideration to lift the condition on the internal transfers of Green Mining.
I'll make that my motion in terms of that separation so that we can do that.
I'm sorry, Chair Douglas, I didn't hear you.
I'll incorporate that into my motion for the acceptance of the part so that we can make a partial transfer at this time. So we have a motion on the floor. Do we have a second?
Member Drett, I second. Should I also add the conditions of the waivers?
Yes, and noting for the record the need for the approval of waivers NCCR 5.110 pursuant to NCCR 5.112 and NCCR 5.125. Our conditions expire on such agenda date as Natural Medicines LLC next TOI application is heard. And that's the condition was the 60 days to kind of clean up the loose ends.
With respect to the ownership.
Yes.
Thank you.
So again, I just want to make the record to be clear that the transfer to Natural Medicine is a final transfer that can then trigger payment obligations. So then we can pay the tax obligation, and then we can address the internal revenue.
That's correct.
Thank you.
We've had clarification on the record. We have a motion. We have a second. All in favor, please say aye.
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 Any opposed? Any nays? Thank you.
Chair, members of the board, thank you so much.
Thank you.
Silver dollar distribution. TOI 21071, T101, and the Empire Company LLC for possible action.
Chair Douglas, members of the board, for the record, this is David Staley, Chief of the Investigations Division. Item F is a TOI application by Silver Dollar Distribution, which holds a conditional distribution license in Tonopah, Nevada. TOI number 21071 was filed in December of 2021, requesting approval for Michael Lack's sale of Silver Dollar and its T101 distribution license to David Baker through his company, the Empire Company LLC. Empire is currently licensed for cultivation and production in Tonopah and wants to add distribution capability for its products. Staff have identified an area of concern regarding this TOI because both Locke and Baker informed the investigating agent that the transaction had already occurred, which was supported by the January 29, 2019 effective date of the asset purchase agreement. The transfer of interest was completed without prior approval by the Department of Taxation or the CCB. I am available for any questions, and my understanding is that David Baker, Michael Locke, and Rusty Graff are available to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Council and parties representations, please.
Good morning, Chair Douglas, members of the board, Director Klemas, and Chief Staley, Rusty Graff appearing for Empire in this. Also appearing with me is Michael Locke and David Baker for Empire. And Your Honor, this is an interesting issue, and it's an interesting issue because this involves a much larger transaction where Empire previously purchased the licenses for Blue Coyote. During that transaction and during the approval of that transaction, they were somewhat instructed by the previous staff of the Department of Taxation to hold off on the transfer of this license due to the fact that it previously involved the federal liquor license requirement, and that required or made it easier for the transfer of an individual in the name of Mr. Locke. They adhered to that instruction, and then they went about, so the actual transfer and the actual transaction was known to the Department of Taxation going back to the original transaction, Your Honor. And they then filed for the transfer of the distribution license to Empire in December of 2021 because of the fact that they wanted to finalize the transaction. It wasn't a matter of that the administrative agency wasn't aware of the pending transaction. Were aware of the transaction. They were told to hold off by the administrative agency, and that's what they did. So now they're presenting to his board so that they can be approved for that purpose to have the transfer complete. This is a 100% transfer from Mr. Locke to Empire. I don't think that there's any outstanding issues regarding fees. We had been informed by staff last week that there were some outstanding fees regarding transfer, and we are amenable to paying those fees within 30 days of the approval of the transfer. And Your Honor, this transfer became all the more important with more recent proposal of SB 33 by the CCB in terms of requiring this type of transfer license or distribution license. And it becomes all the more important for this particular transferee in the fact that their cultivation and production licenses are in middle of the state in Tonopah. So whenever they want to be able to transfer anything else like that, they're at the whim and the discretion of charges by other distributor license holders, and it becomes all the more important for their financial viability to have this distribution license, and that's why we're presenting here today, sir.
Thank you. Questions by board members at this time? And we finally gotten the issue of renewal fees with the proper licensee. But having said that, questions by board members? Just as a narrative that we seem to have an issue that seems to be ongoing. I wish we could put it to bed forever as to information given or not given by the folks that were in charge prior to the Cannabis Compliance Board being adopted by the state. We still have that ghost running around. I would look, so
Chair
this one-
Douglas, David Staley for the record, if I may. Quick question. The cultivation and production licenses C184 and P120 that were purchased by Hempire, were those purchased from the same group that held distribution license 21?
No, and that's what we were trying to explain. Back in the day, there was a requirement that you had to have a federal liquor license to be able to have a distribution license, or there was that perceived perception. It was actually a condition of our February 23rd, 2018 conditional approval is that we had that. So Mr. Locke was a member of, and I don't know if it's, I never represented that entity, Chief Staley, but it's my understanding that Mr. Locke is a member of Blue Coyote entity that transferred those interests to Empire. So it was all one transaction. This was actually held out. They were asked to hold it out by staff.
I'm sorry, one more clarification question. So Mr. Locke previously held cultivation C184 and bulk production.
It was actually held by my business partner, Tom Smith. Him and I owned the property in Tonopah.
Okay.
And so he held those, and because of the way things were split, we were kind of informed it'd be better if I went and got liquor license and a distribution license, knowing that we needed it because we were in Tonopah 3 hours away from any place. And I was working with Damon Hernandez at the time that we went through that. And we were very proactive in both of those licenses because we're in the middle of nowhere. So reached out to them prior to getting inspections, and we actually did get our final inspections for the cultivation production passed the first time, which Chris Jacobson said had never happened before with him. And I was then working with Damon on getting this license done. And there was a lot of things between COVID and how things were switching over that we lost people between, and come out and inspect after I put in cameras and do that to get final approval. And then it's my understanding that it became an issue because I was a sole proprietor, that the transfer that we did, which was identical to the one that we did previously, said we'll just do the same thing because that seamlessly couldn't be done that way because I was an LLC and this was a sole proprietor, which I had to do because of the license.
And the sale of this distribution license in some way is related with the sale of the cultivation and production because of your business relationship with the other?
Yes, it's not related on an actual entity ownership, but it's related that it all culminated together because of the location.
I understand.
Thank you for that information. Kind of deals with the muddy water that we have at this point. I would make a motion to grant the request for the TOI affected by this, also with the representations that the outstanding renewal fees for 2021 and 22 that were shown in the November 3, 2022 license be paid if 60 days is reasonable and the parties are in agreement as to what that is. If not, put a fine pen to it, whatever the dollars and cents are. That would be my motion. We don't need any other conditions at this point.
Member Durrett, I second.
Been moved and seconded. Any additional discussion? Hearing none, all in favor, please say aye.
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 Aye. Any nays? Any abstentions? Matter carries. Thank you, and thank you for providing the information that clarified some of this.
Chair, we appreciate that. We also appreciate the efforts of Chief Staley and Investigator Justice in kind of shepherding this across the line. We appreciate it.
Thank you very much. That takes us to item number G, probably appropriate, Moms and Meds Management. LLC, TOI 220040, C203, P135 for possible action.
Chair Douglas, members of the board, for the record, my name is David Staley. I'm the Chief of the Investigations Division. Item G is a TOI application by Moms Med Management LLC, which holds medical cultivation and production licenses in Hawthorne, Nevada. TOI number 2200040 was filed requesting approval for Laurel Langemeyer to purchase 50% of Moms Meds owned by her business partner, Benjamin Hoskins, resulting in Langemeyer owning 100% of Moms Meds. No areas of concern were identified during the investigation into this application. I'm available for any questions, and my understanding is that Jeff Donato and Laura Langemeyer are available to address any questions you may have as well. For that, Chair Douglas, I'll turn this item back to you.
Thank you. Representations, anything you'd like to say?
Good morning, Mr. Chairman, members of the board. Jeff Donato here with Argentum. With me today is Mrs. Langmeyer, who will become the 100% owner of this business. And also joining us via Zoom is Mr. Ochimoto, just in case you may have questions for him as well. The chief has outlined what the transaction is, and we were here to answer any questions that you may have.
It's nice to have no concerns. Board members, you have anything that you've found?
I think Jeff Donato is known for his clean applications. So thank you very much.
Appreciate that.
If we can have a motion and if we have no question.
Member Durrett, I move to approve the request for transfer of interest under agenda item 5G relating to Moms Meds Management.
Do we have a second, please?
This is Member Young, I'll second that.
It's been moved and seconded. Any additional discussion? Hearing none, all in favor, please say aye.
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 Any nays? Any abstentions? Matter passes. Thank you very much for a clean getaway.
We appreciate that and like to thank
And
investigator
you have one other
Sandrock
matter.
for all her help during the investigation process.
Thank you. Item D is DEC Ops Nevada LLC, DEP Ops Nevada LLC, C010C.
Chair Douglas, I
And
believe
it's for
we're on
possible
item
withdrawal.
5H, Redwood Warehouse withdrawal.
Oh, excuse me. Yep, you're right. Redwood Warehouse, which is for withdrawal.
Chair Douglas, members of the board, for the record, my name is David Staley, Chief of Investigations. Item H is a request for withdrawal submitted by Redwood Warehouse LLC. Redwood appeared before you in February of 2023, where the board approved TOI 2200033, which included a waiver of NCCR 5.110 pursuant to 5.125, as well as various internal transfers for estate planning purposes. An additional sale to an outside group was contemplated at the time, but Redwood requested that that part of the TOI not go forward pending additional negotiations. The parties were unable to move forward with the proposed sale and requested that TOI 2200033 related to the final sale to an outside group be withdrawn. Redwood has also requested a new waiver because the waiver the board approved in February of 23 expires at its appearance in this March 23 agenda. Redwood's waiver request pursuant to 5.125 would exempt its members with less than 5% from having to obtain a cannabis agent registration card. Redwood has adequately addressed the items required in NCCR 5.125 to allow the board to approve such a waiver. Staff suggests that if approved, the board limit Redwood's 5.125 waiver to expire on the next date it appears before you, transfer of interest. No areas of concern were identified during the investigation into this withdrawal application. I'm available for any questions, and my understanding is that Amanda Connor, Leon Kermani, and Maggie McCletchy are available to address any questions you may have as well. With that, Chair Douglas, I'll turn the sign back to you.
Representations for the record, and just to make sure we're on the same page, that the other matter has been withdrawn and you're just making sure that the conditions go forward until your next TOI event.
Good morning, Chairman, members of the board. Amanda Connor with the law firm of Connor & Connor. I also have Derek Connor with me. I believe Maggie McCletchy, representation for Leon Kermani, is available via Zoom. And Chairman, my understanding is this item is to approve the withdrawal of a portion of the transfer. The Placide Group and Mr. Kermani had entered into an agreement, and that Ms. McCletchy can give more detail, but that agreement is now not going forward. So we're requesting the board note that that portion of the transfer was withdrawn. The other portion was approved at the prior CCB board meeting. And because of the condition that the waivers come back at the next time a transfer is on the agenda, we are also asking approval of both a 5125 and a 5112 waiver. Thank you.
Thank you. Other representations, just for the record?
Good morning, Chairman Douglas, Director Klimas, and members of the board. This is Maggie McCletchy of McCletchy Law for Mr. Leon Kermani. Ms. Connor did summarize the status correctly as part of transfers that were originally going to be agendized for last month. There was a transfer from Mr. Kermani to the Placide Group. The Placide Group has determined that it does not want to proceed with that purchase, and so the parties have agreed that that transfer be withdrawn, and the reason we're here is just to formally get approval for the withdrawal of the transfer of part of Mr. Kermani's interest to the Placide Group.
Thank you. Any questions by the board, or do we have a motion?
I have a question. Sorry, Member Dredd. So the reason it's not going through is because of why is it not going through? Why don't they want the subsequent?
For the record,
portion?
this is Maggie McCletchy for Mr. Kermani. The Placide Group informed Mr. Kermani and myself that they did not wish to proceed due to the economic conditions in the cannabis industry in Nevada.
That hurts because that's what I've heard a lot, and now we see it in practice, and we don't always know that that's what's actually going on out there if it's just rumors, but now we know that we hopefully will need to make major improvements in Nevada to attract out-of-state investors.
For the
Or
record,
even in-state investors.
Well, I'm sorry, Member Dredd. For the record, Maggie McCletchy for Mr. Kermani. I agree, it's unfortunate. I know that in this instance, Mr. Kermani and Redwood are continuing to march on, but it is an unfortunate indicator of what's happening in the industry that potential buyers are concerned about moving forward with transactions.
One other thing I have to say, Mr. Donato is known for clean applications, but Ms. McCletchy, Ms. Connor are known for making very complicated things look easy. So that's the other side of the coin. Thank you, Member Durrett.
Thank you.
With that comment, do we have a motion?
Member Durrett, I move to approve agenda item 5H, the remaining waiver request from Redwood Warehouse of NCCR 5.110 pursuant to 5.125 and 5.112.
And a withdrawal of the TOI request.
And in addition, the withdrawal of the remaining TOI request.
With that, do we have a second?
This Member Young, I'll second that.
Been moved and seconded. Any further discussion? Hearing none, all in favor, please say aye.
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 Aye. Any nays? Any abstentions? The matter carries. Thank you. This was too easy for you.
Thank you very much. And thank you to Chief Investigator Staley on working with us to get this completed.
Yes, I want to echo Ms. Connor's thank you, and thank you also to Ms. Connor for her assistance.
That now moves us to item number 6, request for consideration of approval of management service agreements. The first one up is Premium Produce LLC, C033, RC033, P038, RPO38, and Albert Einstein LLC. Good morning.
Chair Douglas, members of the board, for the record, this is David Staley. I'm here to present item number 6, which consists of 5 management service agreements or MSAs. Item A is an MSA between Premium Produce LLC and Albert Einstones LLC for the production of Einstones El Blunto traded branded products by Premium. CCB staff have reviewed the agreement and found the relationship between the parties appropriate. I'm available for any questions, and my understanding is that Amanda Connor, Priscilla Vilchis, and Walid Ladra are present today to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. Representations?
Good morning, Chairman, members of the board, Director Klimas. Amanda Connor with the law firm of Connor & Connor. As Chief Investigator Staley indicated, I have Ms. Vilchis on behalf of Premium Produce with me and Mr. Ladra on behalf of Albert Einstones with me here today. I have a few comments if permissible.
Please.
I would like to note for the record that while this is under an agenda item as a management services agreement, that this is in fact not a management services agreement, and this is a licensing agreement. And I think it's important for the board to have the facts of how this entered or became a part of the agenda. It was not submitted by Premium Produce with a request for it to be brought before the board for approval. In fact, it was requested by CCB staff when they noticed that these products were being produced at the facility. And the licensee provided the agreement for staff to review. It was never our understanding that it would be going before the board for approval because in my client's opinion, in my opinion, it does not necessarily require approval. And I think we need to be careful. I talked to Chief Investigator Staley, and it's my understanding that this is an issue of first impression to the board as to whether licensing agreements or packaging agreements need to come before the board for approval. Pursuant to NCCR 5.1106, there are certain criteria that necessitate agreements coming before the board. And that is namely, if there is significant control or if there is a participation in profits. That is typically what necessitates management service agreements coming before the board for approval. This licensing agreement has neither of those. There is not a participation in profits, and the control of the operations remains with Premium Produce. Therefore, I submit to you that this agreement, while I appreciate staff find the relationship appropriate, I submit to you that it shouldn't be before the board for approval. And I think it's an precedent that, if set, would require all packaging, all licensing agreements to come before the board, which hasn't been a practice and would need, there are hundreds of these agreements out there that then would need to come before the board. I'm happy to answer any questions. Thank you.
I appreciate the position that you have as to this issue. I disagree with you partially. The legislature, and I don't think they'll go back on this particular area, are concerned with the participation in the industry of people who aren't properly licensed before this board. And they're concerned with the activity still in the industry, trying to make some changes to level the playing field financially. But there are concerns as to who is involved in doing what and to what percentage. And without knowing what individuals and businesses have stretched their arms because it's good business into Nevada, we don't know what's going on. The state doesn't. So this is something, as you said, first impression, it's going to have to be sorted out and the rules better clarified. So this is going to have to be put on our wish list to begin to look at going down the road and clarifying as you're indicating today. But as to this one, unless a board member has some other questions or comments.
Member Drat, I wasn't able to make it to our briefing meeting last week, so maybe I would have been better prepared on this one if I had. I did not even, it didn't, the funny thing, I was looking at it like, oh, this is just white labeling. Oh, so interesting that now we're dealing with those. I didn't even know that. So I think the industry does not feel comfortable reaching out in advance of our board meetings. I think they should. I think they do that in gaming. They cannot relating to disciplinary matters, but I think there should be a comfort level of just providing a little brief about what's coming up. I would prefer to wait on this because that's right. I mean, why would we make a decision on one licensing agreement when there's hundreds out there? So I would prefer to wait until we have those rules in place.
Mr.
Any
Chair,
other-
question. A question
Yes.
for our DAG. Do we have an opinion from our DAG taking a position on the interpretation? I know you provided your opinion, and I appreciate that, and I look to your opinion, but I also wonder if there's an opinion from our DAG with regard to this.
Member Freilich, no formal opinion at this point.
Thank you.
Can I add? I think the way that we should approach this is by having the policy discussion first and not having it be driven by having it on the agenda, that we should have the discussion, adopt or reject the regulations around it, or even just a policy discussion, not having it made based on it appearing on the agenda.
Chair Douglas, David Staley for the record. I believe that if the board's action to some degree set the policy to follow, recognize that these MSA reports that go before you are not approvals of the agreements, they're approvals of the relationship. However, Ms. Connor is correct. This neither includes an acquisition of control or influence or participation in revenue. We had some additional information that we had identified, but the board's direction on this item will create that policy on how we look at licensing.
Yeah, it's always a concern when we have, as indicated in the report, it indicates Albert provides to employees who receive their contract, they'll receive their agent card back in June and September. According to the agreement, Albert is paying their employees to work at premium. However, the employee's day-to-day operation is managed by premium. So we have a relationship, and rightfully so, it's to be sorted out. All we're doing is saying, you've provided us this information. There's nothing nefarious in it. We accept it. And at this point, move on. But Member Durrett and Attorney Connor are correct. We need to sit down and take a look at this, to see where the line is of how much we need to know and how much, because of the licensing nature, that closeness we don't need. Or if there's a simpler way to do this. So I would like to see us today to approve this understanding. We're going to have further study. We don't want to get into have licensing agreements in front of us necessarily, but it would be good to know that there is a license agreement in place and see if there's an easier and shorter way to do that. But that's just my thoughts.
Mr. Chairman, did I understand you that you would ask for a motion to approve this until just as is, or would it be appropriate to revert this back to staff for further review and either come back to us or it doesn't come back to us?
It's correct that we don't officially have a line in the sand. Attorney Connor points out there is from a other side as to what is a pure licensing agreement. And the question is how much the board needs to know so we capture what is clearly a licensing and not necessarily a participation situation. That's the fine line. And then just for policy, whether or not in the future, we just want to report it that they have a licensing agreement that meets whatever requirements, if any, if that's where we go, or we just decide, no, we'll stay blind with that. I don't know. But for today, we appreciate we have this. It came up because it was in place. We weren't aware of it. And this would at least put it in a situation where people won't be looking over their shoulders saying, you're doing something and you didn't report it.
Can I add something? Member Durrett, for the record, I think we need to have an open, transparent discussion with those affected by this before we go ahead and set a policy. I would like to hear from others more than Ms. Connor about the pros and the cons and how it'll work in practice, rather than just having now a de facto policy because we went ahead and approved it one time at a hearing. I think because of what I'm saying now, at best, there's going to be mixed messages because the board isn't going to be all in agreement about whether or not we'll be reviewing license agreements. I see why you would want to. I see why an inspector would want to look at a licensing agreement, make sure it isn't operating as the third party isn't controlling the facility. I can see how that could be a problem. I just think this is out of order when it comes to developing policy. First, there has to be the policy discussion and the input, and not just the de facto new policy being put in place by the actions that are taken. So I would oppose even taking a vote on it.
Rosalie Bordelove for the record, just if I can help give some guidance kind of in what you're doing today and what you can do kind of, because we only have this agreement before you today as an agenda item, and you don't really have the ability to make a larger policy. A policy of general applicability starts to lean towards where it should be in a reg. In terms of, it sounds like you kind of already have staff's input with respect to this specific agreement. So sending it back to them, I don't know if that would be real fruitful. A suggestion would be to potentially either approve or reject this agreement with the caveat that you're approving it to the extent it requires approval, or rejecting it to the extent it required approval, but not making that determination and requesting a future agenda item where you have a more full discussion regarding where you want the line to be about which agreements need to come before the board and which don't. And that will direct staff to the extent that that needs a reg change, that'll direct staff to be able to start drafting that reg change and going through that process. But since you can't really do that under this item today, a possible way to look at it is say, if you're comfortable with this, you'll go ahead and approve it to the extent it needs, but you're not kind of making that determination that it needs approval today.
Member Drett, I think that's a great, eloquent solution, because then we're not holding up the relationship, but we are we're shelving that topic of whether or not it requires approval. So I think that's great. I want input from the people who, they've put their lives on the line here. Like I said earlier, I know people who for years weren't able to spend time with their family. They sold their facility, left the state so they could kind of like make it up to their family. I know people have their life investments in this. I want to hear from the people who know how the industry works, whose savings are on the line. They've invested time, they've invested efforts, and just very educated people about this. So I want to hear the ins and outs of it, but I love the solution. Thank you.
Chairman, if I may.
Yes.
Just to chime in, I will not, I haven't confirmed with my client, but I would say that approval to the extent it needs approval would not be objected to on our part, because the main concern would be some sort of policy or standard that it would set if it was just outright approved, given that there are hundreds of licensing agreements already in effect. So I do think, having that policy discussion outside of this one agenda item would be more appropriate. So we would not object to an approval to the extent it did require approval, later on the road, having that policy discussion. Thank you.
Mr. Chairman, Member Freilich, just a question for probably our DAG. The agenda is worded that it's an approval of management services agreement, and council has put on the record that this is not a management services agreement. So I just wonder if am I overthinking this? Maybe I'm overthinking it. How do we get over that hurdle?
Rosalie Bordelove for the record. I think, yeah, it does look like there's a bit of, I mean, you could call it a typo, at least in that, in terms of the organization on it. I think you could still go ahead with approving it, the agreement that has been presented, to the extent that, approval is required. I think you could do that. The other option would be to not take action. The problem is you haven't made that determination whether or not the proposal, whether or not this type of agreement requires approval. So to the extent that no action is taken, it kind of puts on hold, I suppose. It puts it on hold to the extent that you're going to have that later discussion. And I guess it would be the understanding that this type of relationship is probably going to continue until there is further guidance from the board as to whether or not approval by the board is required.
I think the ultimate question is, what is a services agreement? Management got stuck in front of services, but we clearly have a service because of the payment to the two employees. Understanding, I'd like to see just right now an approval today if the board is in agreement. Understanding we are giving a tacit blessing to what they're doing in this case, but understanding, and I support Mr. Rett's position, that we have to have a discussion as to that, bring the industry down in and talk about the licensing in terms of these kind of relationships. Where are we? Is there a line? Is there not a line? What makes sense for the information the state has tasked us to know about the involvement in the industry from people outside the state? But this is just, we're aware of it. There's no red flags or problems with what's being offered. So that's kind of where we're at. I would make a motion for approval, but also request that staff bring this back for a future agenda item. But before that, convene a meeting of stakeholders. And hopefully Mr. Rett will join me with that.
I'm a joiner.
That would be my motion. Do we have a second?
Member Merritt, I'll second.
Moved and seconded. Any additional discussion?
I have a question. The motion is that we're not saying either way as to whether these are subject to approval. We're okay.
At this time, we're approving what's before us today. With that, all in favor, please say aye.
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 Any nays? Any abstentions? Thank you. And one more thing on the bucket list.
Thank you, Chairman, members of the board, and all of the CCB staff for working through this issue with us.
Thank you.
Thank you.
I have a request for a short break. Let's take a 10-minute break and we'll come back on the record.
I'm not bionic.
Wait. On the restaurant box. The problem is if you touch it, the whole system will crash. So you're better off.
Is that why they moved it? Is that one of the issues that we're having?
No, there's been a lot of issues.
How long? Yeah, I know that.
Hello. The guy.
We are back on the record, and unless I'm missing something, all of our board members are present and accounted for, which then takes us to item number 6B, Solus Enterprises LLC, as a C076, RC076, P046, RP046, and SGI Solus Management LLC for possible action.
Chair Douglas, members of the board, David Staley for the record. Item B is an MSA between Solus Enterprises LLC and SGI Solus Management LLC for SGI Solus Management to manage operation of Solus's cultivation and production facility, but also includes for the potential purchase of the licenses by SGI Solus Management. CCB staff have reviewed the agreement and found the relationship between the parties appropriate. I'm available for any questions, and my understanding is that Alicia Ashcraft and Prescott Jones are present today to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Representations for the record, and I'll just say at the top of it, looking at this, the only thing was just a minor concern about a work card being applied for in a timely manner. As I say, work card, an agent card by one of the parties, and that part of the underlying fact is a possible purchase of Solus as soon as January of 25. So we understand that dynamic, but representations.
Good morning, Chair Douglas, members of the board, Chief Staley, Prescott Jones from Resnick and Lewis on behalf of SGI Solus Management LLC. With me today is Kristen Abajian, in-house counsel for SGI Solus, as well as, of course, Alicia Ashcraft on behalf of Solus Enterprises. I'll keep it brief as Chair Douglas, you addressed the concern we had as we went through the investigation process, but this is a request for an approval of an MSA, which generally expands upon a pre-existing licensing agreement between the parties. The issue of the agent card for a couple of the owners has been resolved. So with that being said, I'd be happy to answer any questions.
Questions by the board, and whether or not the individual at this point, or if there's a different individual is moving forward for an agent card.
My understanding that the individual, I believe, has an agent card. Is that or is in the process of obtaining one?
Thanks so much, Chair Douglas. Alicia Ashcraft of Armstrong Teasdale on behalf of the licensee Solus Enterprises. And I just will note for the record as well that Nicholas McLean is appearing by way of Zoom. He's the manager of Solus Enterprises as well. So during Chief Staley and staff's investigation for approval of the relationship under the MSA, they discovered that there was an owner whose agent card had expired. We're looking into that. There was a transfer of interest application for that ownership piece. There are two owners of Solus in essence. This is the LSP Global piece, which goes up to a 100% beneficial owner. It is that beneficial owner that I will also mention is a passive owner. He is not, and his string of ownership is not involved in the day-to-day operation up till now, which is part of the reason for the oversight of having the agent card renewed. So we're looking into it. He's a little bit MIA, non-responsive. So what we asked and discussed with Chief Staley is that we have put in the transfer of interest for that piece of ownership of Solus, and that we bring this before the board to approve this relationship under the MSA with SGI. And then work out what has happened and what may happen on the pending transfer of interest. That's what our request would be today. And I've made the pledge, as has Mr. McLean, that we will figure it out and work with staff and give the appropriate documentation. I will just mention, as has been a recurring theme already today, that the agreement for that transfer of interest does once again make it subject to regulatory approval before it can become effective. So I just put that out there for your consideration. But again, we would just request this relationship be approved, and we will continue to work with staff to work out the concerns on that transfer of interest piece and the missing agent part. I'm happy to answer any questions as is, Mr. McLean.
Appreciative of the diligence and cooperation in this matter thus far. Questions by the board members? Seems like the ship is going the right way in deep enough water. So with that, unless there are questions, if we can have a motion for approval.
Member Dret, I move to approve the relationship proposed under agenda item 6B between Solace Enterprises and SGI Solace Management.
We have a motion. Do we have a second?
Member Merritt, I will second.
Been moved in second. Any other discussions or statements? Hearing none. All in favor, please say aye.
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 Aye. Any opposed? Any abstentions? Matter carries. Thank you very much.
Thank you, Chair Douglas, members of the board, Chief Staley, and your team. Thank you.
Special thanks to Monique Bedden, who worked on this particular investigation. Thank you so much.
Thank you for the shout out. With that, we will move to item number C for a cameo appearance, Moms and Meds Management LLC and Quavis Management NV, Hawthorne LLC for possible action.
Chair Douglas, members of the board, for the record, this is David Staley. Item C is an MSA between Moms Meds Management LLC and Convis Management NV, Hawthorne LLC. The agreement provides for Convis Management to provide management services and complete the build out of Moms Med cultivation and production licenses. CCB staff have reviewed the agreement and found the relationship between the parties appropriate. I am available for any questions, and my understanding is that John Sandy, Laura Langmeyer, and Ranson Shepherd are present today to address any questions you have as well. For that, Chair Douglas, I'll turn that side back to you.
Okay, and representations and
Good morning
the
again.
nature is, as stated, the build out and basically running the operation.
That's correct. Good morning, Mr. Chairman, members of the board. Jeff Donato here with Argentum representing Moms Meds. We're here seeking your approval of the MSA agreement with a very reputable and experienced operator, Mr. Ranson Shepherd's Group. And we're seeking your approval of that MSA.
Questions by board members? And we might note that the central task is taking this from non-operational to operational.
That's correct. That's right. They did perfect their licenses. They have not been conducting business. And the goal is under phase 2 to get up and operational. That would be Mr. Ranson's group.
If there's no questions by our board members, we can have a motion for approval.
This is Member Young. I'll move that we approve agenda item 6C, the relationship between Moms Meds Management and Quanveris Management Nevada.
We have a motion. Do we have a second?
Second.
And seconded. If there's no additional discussion, all in favor, please say aye.
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 Any nays? Any abstentions? Matter carries. Good luck and waiting to see you back before approval to open up.
Thank you. Appreciate it.
takes us to item D, which I was premature trying to get to the end of the agenda. Deck Ops and NV LLC, C010, RC010, Dep Ops Nevada LLC, P009, RP009, T021, and Flourish, I guess, LC, for possible action. Good morning.
Good morning.
Good morning. Chair Douglas, members of the board, David Staley for the record. Item D are two related MSAs. The first is an agreement between DEP Ops NV LLC and Flourish LLC. The MSA provides for Flourish to provide business marketing, human resources, accounting, administrative, legal, technological, financial, and construction consulting to support DEP's distribution, medical and adult use cannabis businesses. CCB staff have reviewed the agreement and found the relationship between the parties appropriate. The second MSA is an agreement between DEC Ops NV and Flourish. The MSA provides for Flourish to provide business, marketing, HR, accounting, administrative, financial, and construction consulting to support DEC's medical and adult cannabis businesses. CCB staff have reviewed the agreement and found the relationship between the parties appropriate. I'm available for any questions, and my understanding is that Melissa Waite and Brandon Canitz are present today to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Representation.
Yes, thank you, Chief Staley. Good morning, Chair Douglas, members of the board, Executive Director Klimas, Melissa Waite with the law firm of Dickinson Wright on behalf of DEC Ops NV LLC and DEP Ops NV LLC, both of which are wholly owned subsidiaries of Desert Evolution. Also present via Zoom is Brandon Knitz. Brandon's an owner of both Desert Evolution and the management company Flourish. He currently serves as the CEO of Flourish and is the sole manager of both DEC Ops NV LLC and DEP Ops NV LLC. We would like to thank Chief Staley, Chris Horpak, and staff for their hard work and attention to this investigation. And we respectfully request for approval of this relationship. And if there's any questions, Brandon and I are happy to answer them.
Questions or comments by board members? If there's no questions, if we can have a motion.
Member Dret, I move to approve the relationship proposed under agenda item 6D between DEC Ops and DEP Ops. I'm sorry, between those entities and Flourish.
Thank you. Second,
Member Young, I'll second that.
been moved and seconded. Any further discussion? Hearing none, all in favor, please say aye.
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 Abstentions, nays, matter carries. Thank you very much.
Thank you.
Thank you.
Item 7, briefing from Chair and Executive Director. I will give my time to our Executive Director, Mr. Klimas, who's up in the wonderful snowbound Carson area and maybe was a participant till midnight on bill drafts last night to give us an update.
We are watching the snow come in as we sit here. So thank you for that. Just wanted to revisit the item that we brought up earlier in the meeting on the proposed extension to submit documents. So, part of the lounge process and for those applicants who were selected to move forward, including the retail attached lounge applicants, they had 120 days to submit the required documents to proceed with the suitability review. That brings that deadline to March 31st, which is Friday. All of the cases have been assigned to investigation staff, and so communication has been happening. As an agency, we've also sent out a number of reminders on that 120-day deadline. But where we're at right now is there's still a large number of those selected to move forward that have not submitted some or all of their documentation. And we've heard a number of different reasons. We've received a couple requests to consider an extension. We also have, as you know, a number of social equity applicants who this is a very new process for most of them. We are making progress, but we are not there, not where we should be by this deadline, which will be Friday. And so staff would like to propose and would like to move forward issuing a 90-day extension to submit the required documentation. We can and we plan to do that. Obviously wanted to bring it to the board to make sure the board was okay, had any concerns that they could share them. And then of course we could answer any questions. I mean, at the end of the day, we've worked over 15 plus months to create this lounge program. Obviously, we do not want to pull any licenses given this deadline. But on the flip side, and this may come back up if the board is okay with an extension, we've also worked 15 plus months. We want to see this program launch. And so we want people who were selected to open their businesses. I think that'll be a conversation that we could have towards the end of any extension that we grant. I think 90 days is appropriate here. We also are battling the economics. And so I think that has slowed the process a little bit here. But with that, I'll go ahead and stop and answer any questions that the board may have. Chief Gilbert here has handled the administration of these licenses, and the applicants. Chief Staley's team, as I mentioned, had been assigned to perform the suitability reviews. And so both of these two gentlemen can help answer any questions if the board has them, but pretty straightforward thought on this.
Take your silence and run.
Great, thank you. Then we're going to move forward with that. The only other thing that I had, Chair, was, and we had talked about it at the last board meeting, we're looking at the second week of April to host the workshop. We will send notice out likely in the next week or two, given the number of regulations that we would like to move forward with, but also receive stakeholder input per the executive order issued by Governor Lombardo's office. So we do look forward to that and hope we get robust participation there. I did want to just add, we hope to have a conversation around air ventilation requirements for consumption lounges. We've heard a lot of feedback on that. There's been some articles on that. We believe, we believe that workshop will be a good opportunity to hear from some folks. I know some people have done some due diligence and gotten some reports and some analysis. So we hope people will come to the table with those reports so that the board can see what's out there. And if there is a change that needs to be considered, we can consider it then. Thank you.
With that, item number 8 is next meeting date of the board is April 25th, 2023. We keep finding new items for future agendas, and I think that is appropriate because this industry is still in the infancy stages and developing, and we need to clarify and correct as we go forward. But having said that, anything else new and pop up that needs to be thrown out for at least get on the minds of everyone concerned?
I have something that popped up since the last meeting. There was a metric training where incorrect information was given about how taxes were going to be collected. And this is probably already the plan, but can I request that metric training be reviewed before it's provided? A lot, there was incorrect information given. A lot of people were panicked. It was resolved by the end of the day. But I think if their training is correct, it's reviewed before it's provided, then that could be avoided. I'd been through this years ago when Metric had provided a new policy in a training, created a lot of panic, a lot of problems. Eventually, after several weeks of meetings, the problem was resolved, and the new policy was unwound because it was not possible to follow through with it. So I think if their trainings are reviewed beforehand and there's no new policies disclosed in them, that it would be helpful. Kara might remember what I'm talking about. Maybe not. I'll remind her afterward. Thank you.
Anything else under that item? Item number 10 is second go around for public comment, if we have any. We see no hands in our bodies in Las Vegas. Do we have any snow? Oh, okay. Woke her up.
Sorry, I'm slow. Good morning, Amanda Connor from the law firm of Connor and Connor. I just wanted to clarify the report from the executive director. He discussed a 90-day extension. I just wanted to clarify if that would be applicable to everyone. I assume some sort of listserv or notice will be going out, but is it applicable to everyone, all license types, or only social equity independent? Thank you.
We'll-
Rosalie is going to get
After-
upset with me
after
for
we
answering
close-
this.
After we close public comment, I'm going to go back to our executive director to try to go with the spirit of open meeting law. Any other open meeting law comments in Las Vegas? Any open meeting law comments in Carson City? Hearing none. Prior to adjournment, we had a statement at the beginning and under the executive director's report about an extension of timelines that will formally go out. Mr. Klimas, if you would like to reiterate, so there's no confusion as to what you said the first go round as to inclusion, and I know it will go out in writing hereafter.
That's correct. It'll be a blanket extension. No application will be necessary, and it will go out before the deadline.
With that, no further ado, we are adjourned at 12:06, these spices on that clock. Thank you.